Feisee. If you don't know me, we got to talk about your disability planning. I'm president of InSight Law. What I want to ask everybody to do is if they can mute themselves during the program, if you're not already muted. Hopefully we have you guys all muted out there. And this program, I'm very excited about it. I think it's going to be, there's a lot of information, a lot what's going on in the world and in the estate planning world as well. So everyone should see 2021 Biennial InSight Law Client Update Program meeting on the screen here, and I will get started very shortly. Just make sure we got everyone kind of squared away and make sure everyone can see me okay. And we will get started. So before I get started with the program, I have some insight and thoughts. Again, we're at InSight Law is an estate and business planning law firm. We're here talking about your estate planning today. And we're updating. We're going through, this is a step in our process for updating your estate plan. And going back over the last 2 years, I always think back and see, you know, what has happened and give some perspective and insight that I see for the client base. And I found that with what happened with the pandemic, the big deal here was, I think, it provided at least a lot of our clients peace of mind. And a lot of other people started reaching out to us, realizing that, you know, that this is an important piece of people's planning to take care of their families or organize their affairs. And that pandemic kind of zoomed that in or made things a little bit more focused for people. From our client families standpoint, we've got tremendous support from our client families. I believe we're really resilient. I really, it's been great kind of seeing all of this and doing your part in the process. And our team, I couldn't be more proud of our team. They just dug in and kept working and kept focused during all this craziness that was going on. And I think it really lends support to our process because things change, right? Things had changed dramatically. And at least from the estate planning side, we think that your plan should be fluid and adaptable, just like a financial plan. The estate plan should be the same thing. We should look at it the same way. And there are some changes to the process because of what has happened. And there'll probably be changes 5 years from now as well. And so things change. And if you're not able to adapt, at least from the law firm side, we're not doing a good service for our clients. A lot of laws have been thrown out after the past few years as well. And to try to make sense of it, my job as a lawyer is to try to help you parse through it. What do you need to know, at least from my perspective? Laws such as the Secure Act, the CARES Act, the Americans Families Plan, the American Rescue Plan. So what are all these things and how does that impact you? If anybody has questions, little housekeeping, just type it in the chat box and I'll address it. And towards the end, or I'll come back at certain points. We just got really today, it's not a time for a lot of Q&A during the program, but afterwards I'd be happy to go through and address any questions or issues that you have. So with that being said, the technological changes a lot over the past year or two, as far as we just had to do things through Zoom like we're doing now. Now we're doing it more consistently, or updating things maybe through our portal or communicating through our portal or different types of, so really the technological changes, there are a lot, and we'll go through how our website and our portal and our technology with the law firm, what you need to be aware of. Personal changes in your families, goals, health, finances, and then also geography. I'm finding people now are moving to different areas, really realizing that they could remote in and work telework that way more often. And then process changes as well. And today we're going to show you one of our at least temporary process changes with regard to updating the plan. So This is a client update program. Typically, our normal process for our clients, who have been with us for a while, the way that we typically do it is it would be a live group meeting. You'd either come into the office or we'd have some type of venue where you would bring in your red books, the red estate planning binders, and you'd bring them in and at the beginning, and you drop them off with our team. And then I would explain what's going on with the laws and the updates to the plan. While I was doing that, my team would be in the back switching out your old documents and putting your new documents in. The way they knew what new documents to put in there is we would send a report to you that I'll get into. It's called an estate planning review worksheet. We call it an EPRW. It's basically an executive summary of your plan where you say, I want to make a change or I don't want to make a change. It's a good, strong template, and it allows you to communicate your changes efficiently to the law firm. And then we put the legal updates in, the things that are not the technical side that support the plan. And so after the presentation, everyone would take their books and go off, and they'd have updated plans. And we do the signings actually at the beginning of the meeting because that gave our team time to swap out the books. So now what we're doing is as follows. We're basically, let's get the education component out there through Zoom, like we're doing today, and the education so that you know all the changes in the law and the updates to the trust and like and what you need to know. And then the signing happens differently now. We'll do in-person social distance signings still. We're on the tail end of this. Hopefully we don't get a flare up again, but you never know. So we're just kind of seeing how things go and playing it safe right now. There are digital signing options. Those are only available if you just don't have any personal updates. Everything's the same. I just want you to put the legal updates in, Bobby. And that's only really for the trust because those ancillary documents like medical directives and wills have different witnessing requirements in a trust. You can just notarize a trust and you're good to go. And so the other documents are a little bit more creatures of statute. And so that's a digital signing option or social distance signing options. This is how, we must receive the way the process works is that we send you an invitation for the client update program meeting, and then you confirm the reservation, and then we will send you that executive summary, your EPRW. But the main thing you have to understand, the point I'm getting across, is you got to send it back to us within the timeline that we ask you to do it, because what we do is we take what you give us and then we actually draft your plan and update your plan with regard to it. We don't want you to send us that executive summary on the day like today that we're actually doing, that we could be actually doing the updates. So our goal really with this client update program is to make sure that you're comfortable with your planning. There's a lot of repetition with regard to the concepts so that you remember a lot of the key issues and topics that your plan will cover, and it's fluid, and that's a big part of it. The purposes of this meeting today is I'll give you a quick firm update, what's going on with the law firm, the document update, tell you what the changes to the documents are. I'll tell you what's going on with the law. Make sure you're comfortable with the website. Make sure you understand our calendar, upcoming programs. And then any housekeeping items, just kind of reinforce that and answer any questions that you may have. The main phone, firm personnel, main phone numbers, and the team, I'm the lead attorney. Wendy Masomer is our associate attorney and settlement coordinator. Joel Keith is our tax attorney. And Ginny Oliver is our funding coordinator, responsible for making sure everything gets titled into your trust properly. Does a great job there. Michelle Tice is our client services coordinator. She helped get us all organized today. She controls my calendar. which is a job in itself. Holly Davis is a new addition. She's an administrative support or funding support position. Ed Clay is our Maryland as a backup attorney for me. If I get hit by the bus, he's agreed to take over my clients, and I've done the same for him. Bill Dunker is our contracts attorney, and he's out in Florida as well, our Florida attorney. And then we just have recently, just this week, we just added in another legal administrative assistant, Bonnie King. So we're growing, and the goal is to add more team members over the next few years. I've got interns from the law school that are working this summer here, and the goal really is to eventually assemble a team that really that understands and gets it and works well with our existing team. So you got a great team, and the point of it is we're growing and we're making sure that we get everything covered. Nava is part of the team as well. So she's getting into lacrosse. She likes feeding the animals and going to the zoo. We couldn't actually get out of the car because of the because of the pandemic, but she enjoyed that. And she's driving already, so very good. So that's the firm update. The document update, let me tell you what the main thing is. We're not going to be signing today, right? Because we're filtering out the education ahead of time. But the changes that we do and update your legal documents are based off of that estate planning review worksheet. So you really just need to be comfortable with that. So I'm going to show you, a sample estate planning review worksheet. Because if you understand that tool, you were way ahead of the game, and you understand, how to operate it. And so if you need a refresher on it, we actually on our website there's an estate planning review worksheet, kind of a summary and how to use it on the website. So that's also available for you. But it's an executive summary. It reflects your requested changes that have been incorporated into our system. And so most of you will have the following provisions of the estate planning review worksheet. I'm going to actually pull one up so that you can see it. And okay, it looks like this. This is our sample estate planning review worksheet. And the point of this is the first one is, hey, are the current trustees of the trust, have there been any changes? So if you remember, the trust is simply, think about the trust as like a little living trust box. But the reason why that currently trust planning, I think, is the best way to plan on the estate planning side is the laws are really stacked in the favor on the trust side. So one good benefit of the trust is if we create the trust, it's like a will, but it's better than a will in that one aspect of it is if we set the trust up right and get everything properly titled to the trust, then there's not going to be a court proceeding after you pass. So that's nice. It also centralizes management of your assets, and at the current trustees are the people who are in control of the plan at any given time. So if you're single, you're going to be typically the sole trustee. If you're married, then there could be, both spouses are typically the trustee. So are there any changes to the current trustees? Yes or no? Typically it's no. The disability panel is not people that are making healthcare decisions for you. Okay, a lot of people get this one confused. These are the people, if we were sitting around a table, who do I trust to answer this one question? Can I effectively manage my financial affairs? All right. And typically it's there'll be a healthcare provider or a doctor involved. And then it's also, if there's in a married couple situation, oftentimes it's a spouse. So when my doctor and my spouse agree, then I'm disabled. It's not something where you just wake up one day and have Alzheimer's or dementia. The family component, we think that it should be kind of a combination of a medical and a family component. And you can build and when we go through the design process, if you recall, you can build your panel any way you want as far as, hey, I want a second medical opinion. I want my siblings on there, or I want these backups. And that's what a disability panel. Are there any changes to that? Specific distributions of trust property. So after I pass away, or after my spouse and I pass away, are there any specific distributions that I want to go off the top to people? Cash distribute, $10,000 to an aunt, $15,000 to a nephew, right? Or to a charity. Are there any specific that is just going off the top that's not going to the immediate family? And then these marital trust provisions and family trust provisions are tax planning provisions that are in married couples plans that say, basically taking advantage of both of your coupons. So that it says when one spouse passes away, the option is, okay, I want to leave my assets for my surviving spouse. And that's typically what these provisions are about. And typically the surviving spouse will have access to all the funds left by the deceased spouse. But there's options that are out there. The spouse ability to modify the trust. So when one spouse passes away, one option that a lot of people like to employ is, I want to leave these assets to my spouse, and she can access it, but not for her creditors to access, and a protective trust for her. So those are my assets that I'm leaving to her. And let's say that, hey, I want her to be able to modify things so that if she sees things going on with NAVA or the like, that she can modify my plan, even though it passed away, but still get the get the protection that is afforded, the creditor protection that is afforded by leaving the assets to her. So that's what modification of that. And you don't have to. You can leave you can do the modification or you're not. And then the remarriage protection is if there was a remarriage after I passed, hey, do we want to protect the inheritance for NAVA or or your kids or any of those situations? That would put it in that provision where if they do get remarried, make sure that those assets go to where they need to go on the death of the surviving spouse. So those are what the marital and family trust is all about. Common trust provisions, sometimes we put this in here where if we have a piece of property that we want to keep in the family, or if we have multiple minor children and just want to leave everything in one bucket to them, we sometimes employ that. And then the trust beneficiaries, hey, after we both pass away, who do I want to leave those assets to? So those are your beneficiaries. You can make changes, yes or no. The final trust beneficiaries, I call this the bad potato salad at the family picnic, right? This is if everybody gets wiped out and you have no beneficiaries down the bloodline, no kids, grandkids, right? Where do you want the money to go? The default rule that we put into your plan is, hey, if we don't have anyone down our bloodline, find the closest relatives. And typically it will go no one down the bloodline, go to parents. If no parents, to siblings. If no siblings, down to their kids. And if you didn't like that distribution pattern, then you would say, I want it to go to this charity or something along those sides. Anytime you see the word trustees, these are people who are in control at any given point in time. So the disability trustees are the people who manage the assets during a disability, if you're not able to do it. And your backups. And then the death trustees after death, who do you want managing it? Usually it's the same people. And then the beneficiaries of the separate trust shares for the kids. So, and we'll get into that today. That's one of the changes to the trust-based planning is that, hey, do I want to leave those assets protected for my kids? Is there something there that's worth protecting for them as well? Trusted advisors, if you have a financial advisor or CPA that rises to a level of a trusted advisor that you want them to be consulted after you pass, then that you can put that in as well. The distributions of tangible personal property, those are your special stuff list. Believe it or not, the fights don't occur between the family members over the big investment accounts. It might be over dad's alligator belt or mom's Hummel collection. So let's get those issues off the table ahead of time and just knock out, designate who you'd want. So you do have a will, but it doesn't do much. If we've got our plan tight, the poor of a will, a poor of a will sounds nice, but I call it the legal pooper scooper. It cleans up after your mess. It says, if there was something that was not put into your trust during your lifetime that you should have put in your trust during your lifetime, scoop it up and put it in your trust after your death. So pour it back in after. So the good news is those assets that were not titled properly will eventually get distributed to your beneficiaries. The bad news is we're taking a stop at the probate court office before it gets there. So there's increased administration. So typically, we have fully funded trust and we're not having to go through probate. So that is really not a big deal on that side. But For our clients with minor children, we have you do appoint your guardians in your will, because the court wants to make sure that they are suitable, they're not felons and the like. So the guardians do have to come to the court. You can't get around that one. And so there we go. And I will go ahead and I saw some questions come in. I'll address them towards the end, but I will make sure I get to them all. The power of attorney, financial powers of attorney. So just so that you know the structure, everything that I can stuff into your trust, we're gonna put in your trust, and it's a very powerful way to manage, centralize your assets, and the trustees will control those assets at any given time. But certain assets I can't put into your trust, or there would be a bad negative tax effect, like an IRA or 401k or a retirement plan. If I change the title of your IRA and put it in the name of your trust, the IRS says, that's a distribution. And if you know enough about IRAs, anytime you take a distribution, that's when taxes are due. And I want to minimize your taxes. I don't want to increase them, right? So the IRA is a contract. It will go to those beneficiaries that we've looked at on the funding side to make sure it gets to the right place. And there's been some changes there that I'll talk to you about in the Secure Act with regard to that. And but if you become disabled, it's not a trust, so the trustees can't manage it. So we just need another legal document that does the same thing as a trust, but for those assets that I cannot put in the trust. And that's what a financial power of attorney is, all right? And we have two flavors of them. One is a limited and miscellaneous, which is only effective once you become determined to be disabled. That's the one that we give to you, and we like that one. And then the backup that we keep at the law firm is the general durable power of attorney, which is effective when you sign it. So someone has to come to us before we release that. The power of attorney for funding, this is for the law firm to be your agent, not to manage your assets, but if there was something that was not funded and you're in a disability situation, that we able to maybe move those assets into your trust to get it done before death occurs, or we can get things cleaned up ahead of time. Don't like to utilize that one. All right, that's an emergency one that we have you sign, and we haven't really had to use it more than once. And so my thinking when we go back to our firm retreat, that we look at our processes, we look at it as, do we want to still keep this? It's a nice protective measure, but it is additional documentation that we have to manage. The healthcare power of attorney is typically the advanced medical directive. There's a lot of different names, but basically that's the one person or the agent that you designate to make healthcare decisions for you when you cannot communicate them to the doctor yourself. And then you sign it, and then where's the location of the portfolio, your red book. If someone asks us after passing, we can tell them, go here. That's where the appropriate people will be able to do it. Permission to contact family proactively is becoming kind of an increasingly important issue. This is where we suspect elder abuse if people are taking advantage of you, and there's not a formal diagnosis. And if I'm concerned, and you say, if you are concerned, Bobby, you can talk to these people I designate as trusted family members that you can reach out to, and I'm not going to be violating any ethical confidences to say that we're concerned, and advise them of what we think is going on in that scenario. And then the miscellaneous issues, this is important. This is a way for you to communicate what's going on with your life. I review these just to say, these are kind of bullet points that, hey, if there is a health concern, we want to know ahead of the game so that maybe we can head legal issues off at the pass. 72 is like the magic year now for required minimum distributions, and we'll talk about that too. So that's the estate planning review worksheet. It's really, and I'll tell you, the programs that you attended as well. Very important tool, and it's a great way for us to keep on top of the plan. All right, and so all the stuff that I had gone through are these slides that I'm going through now. And the medical directive, a lot of people were asking us, hey, does a medical directive need to be changed when it comes to with regard to COVID now? Because there are ventilator machines that I want to use if I have COVID. And so the directive does not need to be changed, okay? Unless you want a different person to be serving as your agent, then that's the case. But the key is that you make sure your instructions are clear, and I'll go through that. One of the issues we'll talk about today is I really want to make sure people understand, what the directive does, and that, that you're clear in communicating your wishes. And so the more important thing is you review your healthcare letters of instructions and checklists that we have you do in the initial design. And if you haven't done them yet, this is a great time to do them or update them, and have a conversation with your healthcare agents. That goes a lot further than any legal document that I have, because you can't foresee everything. And so I'll show you the checklist and the like. I'm just kind of identifying the issue for you right now. And so to kind of zoom back and to kind of look at the overview, for your plan to work, your overall estate plan to work, this is what we found consistently. This is how if we've got these things covered, you're in good shape. Number one is that estate planning review worksheet. Is it updated, right? That gives us the latest instructions for you, your personal instructions. So now I know what you want in 2021. Your asset review report is another important tool. As long as that's updated properly, then we're in good shape as well. So if you look at the asset review report, the asset review report is nothing fancy, but this just lists your inventory of assets so that if something happens to you, I don't have to play Sherlock Holmes to go find everything, right? I hit a button, I know who to contact, I know where everything is at. The other thing is we want to make sure we have some type of mark on the left side saying a check mark is, yep, it's verified, it's titled to be, the new owner means RLT is our acronym for Revocable Living Trust. We've got it titled in the trust, it's not going through probate. And then you just give us the new values. We send this to you as part of your renewal packet. It's on your portal every year in December. You update the values for us. If you sold something, you edit that, you take that out, you buy something new, then we add them here. Okay. Just a couple of things is, hey, if I don't have any markings on this, like I'm worried about what's going on with this Apple stock, right? So if there are on your asset report, there are typically comments that Ginny will provide or funding department will provide. Pay attention to those and follow up on the items that Ginny has identified. And if you haven't done, if you're not fully funded or we don't have an item indication of what's happening for each of the assets, like a motor vehicle, we don't fund those in specific jurisdictions. We don't have to do that. So there's an X, that's something that we don't have to do. So I know we're in good shape. But the retirement plans, I'm not sure that we have the beneficiary designations in this situation. So help us help you make sure that the planning gets done. So if you do have issues with your asset report, or we have items that are not addressed, this would be a great time to kind of get motivated in doing that done again. So when you think about it, right, now I've got your instructions laid out on one report. I've got the assets, another report. Man, that's a really good spot to be in with it. And that's, I think, miles ahead of most firms, right? And then now the personalized instructions. And that's what I'm talking about with the healthcare decisions, right? COVID decisions, right? Or in different scenarios. And so let's talk about those personalized instructions now a little bit. So you want to review your healthcare checklist and have a conversation with your agents. So if you remember, the healthcare checklists look like this. And I'll show you later on in the when I go through our website how where this is blank forms. But you have these forms, and so you just, it goes through situation A is really bad, right? Situation, doctors say there's no hope, and it breaks down the treatment. Situation B, you got a small chance. So each situation is a little bit different. I think the value in this form is just talking through those issues with your healthcare agent, because you can't predict every scenario. But if you can put that agent in as good a position that this is what they would have wanted, right? When my dad, he had dementia, we were guessing what he wanted. He didn't do the planning like, we're doing it now. And it's a big burden to put on the healthcare agent, because he could not communicate to the doctor. So we were making all the calls for him, but we didn't know exactly, how all the issues. And this letter of instruction to the healthcare agent is more where I find it's easier to edit than to create. So, take what you like and just you mark things off. You can write things in here. It's more customizable for you. And again, a nice way to facilitate the communication with the healthcare agent. And then I like this question. This is something that kind of lays out, healthcare planning is not always, black and white where it's the pull the plug type of thing. Yeah, that's kind of like the end deal is your constitutional right to die. That's one issue that's covered. But what about all those other decisions, healthcare decisions? So I like this scenario, kind of get you thinking about it. So how you will answer, kind of will inform your helpers on how you wish to be treated in a case they need to make medical decisions on your behalf. So you're outside the operating room and the doctor comes out and says, I can help your loved one. There are one of two procedures I can use. The first procedure was developed at Johns Hopkins University 2 years ago, and I trained in this procedure 4 months ago. I know how to do it, and if it works, your loved ones will be as good as they were before this happened. However, if I use this new procedure, you need to know that 20% of the people die. Number two, on the other hand, I've been using a more conservative procedure for the last 10 years. I've never lost a patient. I do not know nationwide anybody has died from the procedure. However, people who have this more conservative procedure are always severely disabled afterwards. What do you want me to do? I should say do you want me to do? And so the point of it is, how aggressively will you want treatment? What do you consider to be disabled? These are conversation starters, right? And that's the point of that, is to kind of get you thinking it, and it's not so black and white, but all those other decisions that are out there. How aggressive do you want treatment? Is it something where, hey, I'm an active lifestyle, I want to take that risk, or no, I don't want to take that risk, or I would take that risk, but you got to tell me what, how far disability takes. Will I not be able to talk at all? Some cognitive ability, or is it just physical? So these are things that are open-ended questions for you to think about. So that was that. And so now the legal update. Okay, so laws, a lot of laws being thrown at us. The American Families Plan, the CARES Act is still kind of hanging around back there. That was the legislation passed in response to the coronavirus. The Secure Act is dealing with retirement plans. The American Rescue Plan Act was just passed, so the new administration that was out there. So you got a lot of laws that are flying around. The American Families Plan is a proposal. It's not law yet. And that's really dealing with the income tax. So that's what they're all arguing about now. We'll hear more towards Labor Day because they got to get their act together. But it's kind of quiet now. At the beginning of the year, there was a whole push, and now kind of quiet on the tax end as far as what the main proposals are. But this is what that they had released is, taxes are going up. They're going to increase the top income tax rate. Currently, the top income tax rate, they want to 37% up to 39.6. And then we don't know exactly what the precise income thresholds will be when you get to that top bracket. The White House says it would apply to the top 1% of Americans. Okay, that's the guidance we have right now. The other one that we see is taxing long-term capital gains as ordinary income for any taxpayer with annual income of more than $1 million. Okay, so currently the capital gains rate is either at a 15% tax, you're taxed at 15% or 20% usually. There's a lower tax bracket if you're in the lower, but usually people are hit with a 15 federalist capital gains rate or 20%. This says no. If you're going to make, if you make more than $1 million, you don't get those rules. You're going to be at the 39.6%. There's some other add-ins like the 3.8% surtax, Medicare. So it really would get up to almost like 44, 45%. And if you add state tax on there, maybe 50% for those people. And, that might be, you might say, that's fine. If you're making $1 million, then you should be doing that. But for business owners that are selling their business, a lot of times that's the year that they sell their business. That might be the 1 year that they get the hit over the $1 million. That's where we're finding business owners are concerned that, hey, if I sell my business for more than $1 million, It's not a 20% capital gains rate. It's going to be 50. So that's what people are concerned about as business owners on that. They want to eliminate the step up of basis at death. This is something we don't know if they can get this through because there's a lot of administration. But just real briefly, the way it works is that if I owned a stock like Apple stock and I bought it for $10, if I was lucky enough to buy it for $10, right? And if I sold it for, let's say, $1,000, I would have, during my lifetime, I would have a $990 capital gain, and I would either pay 15 or 20% capital gains tax on that gain. But one thing that you can do when you, one provision in the law that they haven't gotten rid of yet, they want to, is that if I didn't sell that stock during my lifetime, but died with it in my estate, then when I died, then that Apple stock would be at $1,000. They would reset the cost basis for my beneficiaries at $1,000, where they could, it's as if they bought it for $1,000. If they sold it the next day, then that would be a zero capital gain for them. Okay. So they want to get rid of that provision and say, no, no more step up in basis. We want to have it. It's as if you sold everything at death. Death is a realization event. That's what that means. You sold everything. And then they'll give you an exemption of $1 million. They'll say, okay, anything over $1 million is going to be a capital gain. And so that's what they're arguing about. And maybe they're thinking about, okay, if you have a spouse, is it 2 million or 1? So those are the things that they're fighting over now. And just to be sure that you understand, a lot of people make a mistake. Anything in your retirement plan, like a 401k or IRA, will never get a step up in basis. Okay. When you take money out of a traditional IRA or 401k, it comes out as ordinary income. You've never paid taxes on it. The IRS says, no, even for your beneficiaries, if you leave it to them, they're going to get a tax at ordinary income tax brackets. Okay. And then finally, the last thing, allocating additional resources. They want to put more to enhance tax audits of households with more than 400,000. So they want to pump more money in to have more auditors. And if you're making more than $400,000 of income, there's a higher likelihood of audit if we have more resources. The IRS has more resources to do that. That's the families plan. It's not law yet. That's what's going to be discussed. That's what's going on now. And if this has legs, if they can get the votes, then we'll hear more about it either in September, or they might kick the can down the road till like December 31st, right at the end of the year. And it will likely be viewed through what's called a reconciliation versus just a passing as law. As far as a reconciliation is where they don't have the votes, they don't have the required 60 votes in the Senate, and if they just need 51 or a tie break where the vice president comes in and would break the tie, then they could do it that way. The drawback for the reconciliations, at least for the administration, is these are not permanent. They can only keep them permanent they can only set them for 10 years and then it goes away. Okay, so that was what's going on there. Now the Secure Act. So the things that you need to know about the Secure Act from my perspective is it delays your required beginning age date to age 72. So if you don't know what a required beginning date is think of this envelope as like your IRA, and you have your money in your IRA. And the idea behind the individual retirement account is that Congress wanted you to save money because they feel Social Security is not going to be able to sustain you during a requirement. So they get these special accounts that you're not paying taxes of this money while it's in here. It grows tax deferred, it's compounding. But when you take money out of that, right, then it gets taxed as ordinary income to you. Well, the rules of the game are, hey, you can't, this is for retirement. You can't touch it too early. If you take it before 59 and a half, we're going to hit you with a 10% penalty. And if you take it too late, that is, if you kept it in there too long, we didn't get the IRS and get to tax that money, you're going to be penalized even more. It's an excise tax. It's a 50% of what you should have been taking out. And so that required beginning date is when you have to start taking out. Under the current law, under the old law, it was you had to start taking out at age 70 and a half, the nice round age. Now they've delayed it a bit. They say, no, you got to start taking it by age 72. Okay, so that's good. You get to keep it cooking a little bit longer if that works for you. And there's no age limit on contributions. Now, you could, before you had to stop contributing to it once you hit you can now keep contributing to it past age 72 as well. And so this is just so for you guys to understand, if you were taking your required minimum distributions, RMDs, prior to 2020, then you need to take your required minimum distribution for 2021. So I forgot to mention, if you remember the CARES Act, which we'll get to, that's the Coronavirus Act legislation. Last year, they gave everyone a pass. They said, hey, you do not need to take your required minimum distributions for 2020. Everyone got to skip it, okay? But now, if you were doing it before then, you got to do it this year, all right? If you are 73 or older this year, then you must take your RMD this year. If you turn 72 this year, then you can take your RMD this year, which is usually recommended, or you have till April 1 of the fall of 2022 to take your first distribution. All right. And so there's pros and cons of delaying that, because it bunches 2022 distributions. You would take 2 that year. So does that make sense for you or not? That's more of a financial planning issue. You talk to your advisor on that end. All right. So the bad. So what the Secure Act does is it hurts from the estate planner side, the beneficiary designations. Okay, that's where the Congress wanted. They were realizing that this money was being these monies in these retirement plans have not been taxed. All right, and so if we can leave it to beneficiaries who are really young, the rules favored them. Where if a grandparent left their IRA to a grandchild and the grandparent passed away under the old law, then the grandchild would have to take a required minimum distribution. They do have to do it over their life expectancy. Okay, and there's IRS tables that say, hey, if you're 20, then your life expectancy could be 60 years, and so there's a very small slivers that would need to be taken out versus someone who's older, and so it take a long time for that money to come out and be taxed. So basically, the IRS said, the Secure Act says, you're not going to be able to do that anymore. For spouses, we get it. So if you're married and you leave your IRA to your spouse, they get to roll over that IRA and they use the same rules as you do. So spouses, really no changes for regard to spouses. But it's that surviving spouse leaving it to a child, or a single person leaving it to a beneficiary, right? Then that is where the issue, and they say, none of that stretch out anymore. We're locking this down at 10 years. Okay, so that's what the big deal is with regard to the Secure Act. Is for owners of IRAs who died after 2019, it replaced the ability to stretch out payments with a 10-year payment rule. Okay, again, it's not for spouses. Spouses always get the pass. This is for that next beneficiary in line. So the exceptions to the 10-year payout, there are certain beneficiaries who are exempted from this. Okay, the 5 categories are, go figure, surviving spouses are exempt from this. A person who is not more than 10 years younger than the IRA owner. And so that would be, like in my situation, that could be my sister. If I wanted to leave that to my sister, she is not more than 10 years younger than me. She's older than me. A minor child of the IRA owner. So if I left it to NAVA, then she would have the ability to have it stretched out up till she was 18 years old. And then at that time, she would have to take it out over 10 years. Okay, so she could probably stretch it out till she was 28 if I were to predecease. And then a disabled person or chronically ill person, those are more disability issues. But that's what the deal is with regard to the Secure Act. Okay, and so to kind of bring it home to the trusts, there's new provisions in the Secure Act, and it's all about terminology with the, and so these new beneficiary designations, it's called an eligible designated beneficiary now. Before, it used to be just called a designated beneficiary. All of those provisions are in Article 5 of your trust. So Article 5 of your trust is titled Beneficiary Designation Assets. So a little teaching point, there's only 3 ways you can own anything: your individual name, jointly, and by contract. Okay, IRA, that beneficiary designation section in Article 5 are dealing with contracts. IRAs are contracts. They have a beneficiary. life insurance. So that's where we put those in, and that's not going to change for you. That's just going to be legislation. And our goal is we're going to update it to maximize the stretch out period that you have for any of whoever you've listed as your beneficiary. We're going to give you the maximum stretch out period possible under this new definition. Okay. Planning applications. These are things that you could talk to your advisors about, but because the taxes are going, people feel like taxes are going up, and the IRA money is one bucket where, hey, if we take money out and it comes out as ordinary income when we take it out, if taxes keep creeping up when I retire, Uncle Sam will take a bigger chunk of my retirement plan, right? My $1 million retirement plan is not really worth $1 million because I've got to pay. There's money that's going out, could be as high as 40%, 45% if you're in the highest tax bracket. So some people are thinking about, hey, does it make sense to do a Roth conversion? Again, my goal is not to teach you about all the financial products, but a Roth IRA is one where you pay the tax up front and into a retirement account. So you actually pay the tax now, and then all the earnings will go tax deferred. And when you take it out, it comes tax free. So hey, some people are saying, let's pay the tax now because we think it's going up. And my situation affords for that. And so that's what people are thinking about doing. What it means by suspension of minimum distribution rules for a Roth IRA, there is no minimum distribution for the client, for the participant. And typically you want to use non-IRA funds to pay the tax. So if you don't have IRA funds to pay the tax, maybe it's not a good, maybe it's not a good plan for you. Because if you're going to use the IRA money to pay the tax, then that's not probably a best efficient use of it. Taxpayers who this might be helpful for is if you've got losses to offset, or investment tax credits to use. So, hey, this is a good year for me to do it because I have a lower tax burden, or I have some credits there. And so the Roth conversion, after conversion, the growth grows tax exempt. There's no RMDs for the participant. Avoids future income tax rate increases. I don't care what the tax rate increases are because that's coming out tax free. And also in a married couple situation, it'll compress the surviving spouse's income tax bracket, right? So that IRA money, if it's a traditional IRA being provided to the spouse, that's going to add to their adjusted gross income. But if it's tax-free money, they're going to stay in a lower tax bracket. Life insurance is another thing that we're seeing some of our clients. You can permanent life insurance has what's called cash value buildup features that can be accessed on a tax-free basis. The life insurance lobby is very strong, so they've got some good laws on their side. Death benefits come in income tax-free and the like. So that was just something to just throw out there. So CARES Act. So the CARES Act was that coronavirus act, and that was passed in last year timeframe, and it really was there to help small businesses keep going during a difficult time. Recovery rebates for individuals who met certain adjusted gross income guidelines. It did have those retirement plan modifications, things like, hey, you don't have to take your required minimum distribution. Increase the ability to do more flexibility on the charitable contributions and the business tax relief side. So the small business programs, if you're business owners, you're probably familiar with, hey, PPP loans and loan forgiveness. So most people now are in that loan forgiveness phase or have done a second round of their PPP loans and are utilizing that. EIDL loan grants, those are other SBA types of loans. So these are programs that are out there. We had done some business programs for our clients that went through that. That was last year. And it just addressed different programs for business owners. For individuals, there were recovery rebates, $1,200 for every qualified taxpayer, $500 per child. And so the subject to phase outs though. So, you would be phasing out for single filers at around 100,000. And if you're joint filer, around 198. And then the retirement plan rules that it relaxed, it said, hey, it said you could take premature distributions from your retirement plan without that 10% penalty. Okay, so that was one thing that you could do. And if you're trying to take it from your 401k, then the plan must authorize it. And Now you would be in your distribution phase where it says, okay, I took it out last year. If you're one of those people that took it out prematurely, then you have the option to pay that, can spread that over 3 years, that tax payment versus paying it all in one lump sum. And so that is something that is very specific. If you did that, had that hardship, you did take that money out, that's kind of, you're in the next phase of that is, okay, now what is my options to pay the tax? If you're charitable contributions, basically, typically there would be you can make charitable contributions and they would be limited as far as how much you could take a deduction up to a percentage of your adjusted gross income. It used to be, 60% limit typically for the cash, the charitable contributions. For this year, for last year, and they extended this one for this year, it's 100%. Of your adjusted gross income. So if you're someone who is in a higher tax bracket and making charitable contributions, you may want to look at, hey, do I want to make more charitable contributions this year, knowing that I can get a bigger deduction? And those deductions will carry forward in future years as well. If you're not itemizing, you can obtain you have to itemize to get that. If you're not itemizing, then you can get a $300 charitable deduction off the top, or $600 if you're filing jointly, and it is above the line charitable deduction, and that was extended for 2021. So that's kind of what's going on in the law. The other thing with the law is, just to give you a quick what's happening with the fact sheet with the American Rescue Plan, right? So the American Rescue Plan, you may have received, if you have kids, or you may have received a letter anyway from the IRS saying, hey, the American Rescue Plan will provide you with a tax credit if you have kids that are under between the ages of 6 and 17, but they phase out, right? So, they start phasing out once you make more than $150,000 if you're a joint filer, and $75,000 if you're a single filer. So that's, you might have gotten that letter in the mail. That's what that's talking about. The American Rescue Plan, which is law, has basically provided a lot of money to the different organizations, state organizations, IRS, and child tax credits. That's what I just talked about. State and local fiscal recovery fund. The American Rescue Plan provides for $350 billion in emergency funding for state, local, territorial, and tribal government to remedy the mismatch between rising costs and falling revenues. And so you can see, where that's going. Capital project funds. American Rescue Plan provides $10 billion for states, territories, and tribes to cover the cost of capital projects like broadband infrastructure. Homeowners assistance funds, $10 billion for states. This includes to provide relief for our country's most vulnerable homeowners. A minimum of $50 million for each state, District of Columbia, and Puerto Rico. An explicit mandate to prioritize socially disadvantaged households. The law prioritizes homeowners that have experienced the greatest hardships, leveraging local and national income indicators. Emergency rental assistance, okay, and state small business credit, so provides $10 million there. That will expand, provides capital $1.5 billion for states to support businesses owned by socially and economically disadvantaged people. Incentive program to boost funding tranches that show robust support for such businesses. $500 million to support small businesses with fewer than 10 employees. All right. Some employee retention credits. So if you're an employer, there are some employer retention credits that are available to you, $7,000 per employee per quarter. This is something that you should talk to your accountant about, but there are opportunities there. They've extended that through 2021. All right, sorry, there's a lot of laws out there. It was not made to be, specific everything. The ones that I find that are important that you need to know, and kind of the key items that I see that are out there. All right, so the major trust changes. Let's go into that. They're dealing with the income tax issues. This is after you pass away. I'm going to explain this concept of a distribution protector. We're moving over from what's called a distribution trustee. Planning for digital assets, that's becoming a bigger and bigger deal. I want to make sure you're clear on that and that you know how the services that we're utilizing, the alliances that we're using to help coordinate managing the digital asset transfer, and IRA language like I talked about in Article 5 of the trust, and then estate tax law updates. So the big thing that is these income tax provisions in your trust after you pass away. And I have a story for it. You may have heard it before. I call it the cookie jar story. And it's there to highlight how the trust income taxation works. So when you're alive, your trust, you have what's called a revocable trust. So I call it, you have your open bucket, right? You're alive, you can get in and out of your trust. You can use assets for whatever you want. It's not an asset protection play for you as far as, hey, I put stuff in my revocable trust. Now I don't have to pay any of my bills and I'm protected from creditors. No, that's not what that means. It centralizes management of your assets. But if you took out a loan or can't pay it, or you have a creditor, they can access the assets in your revocable trust. And while you're alive, the trust is called a grantor trust for income tax purposes. And that means the IRS says, we don't care that you created this trust. We're going to tax you just the way that we always tax under your normal ordinary income tax rates. The IRS doesn't care about these revocable trusts while you're alive. It's a disregarded entity for income tax purposes. But when you pass away, your social security number dies with you, right? So there's no income tax bracket for you. Now we put the lid on. Now we can leave that inheritance protected and leave it for your beneficiaries where they can access it, but outside parties can't, right? We have that creditor protection. But now the income taxation will change on the trust, okay? And so trusts that are after you pass away, then they call them non-grantor trusts at that point in time. So you're a grantor, you're alive, now you're dead, now a non-grantor trust. Now trust will be taxed at compressed tax brackets. It's the same tax brackets as your normal, it's the same tax rates as your normal tax rates are, but you get to the highest tax rate very quickly, right? So if you're a joint filer, you've got to be over $400,000 or more to be at the top tax bracket. It's very high. For a trust, you have to be at just $12,500 of income to be at the top tax bracket. And so, wow, that's a big deal. So how do we get around this? So typically what we would do traditionally before we had this provision is we say, okay, have the beneficiary distribute whatever income they have, distribute out the income to them, and then they pick up that income on their own personal income tax returns at their rates. And that's how you dealt with it. Just take the income out. If you need more, you can take more, but keep as much as we can protected. Take what we have to take out to satisfy the tax ban. The cookie jar provision changes the game for that and gives you lets you have your cake and eat it too. So with regard to the cookie jar, so if you remember, like when I would be with kids, I'd ride the bus, right? And I'd come home. When I came home from school, I'd run into the house, and the first place I'd go is for the snacks, and I would go and go to the cookie jar, right? And I just reach into it. I wouldn't even have to get to it. And this is where mom is kind of like the superhero in the story. They're like the heroine in the story. She has a super hearing that she could be upstairs doing something else, and she would say. And I wouldn't have to, even get to the cookies. She would say, no snacks before dinner. And I'm like, how did she know that I was even near there, right? I don't even know, how could she see that? But the point of it is this. We structure the trust language that says for the IRS, hey, the beneficiary has the right to go in there and access those funds. They don't have to take it, okay? And by just the virtue of them having the right to take that money, there's IRS laws, regulations, and case law that say, if you have the right to take the money, then we're going to tax you at your income tax bracket. Okay. And so the laws used to be flipped where that was good for the IRS. It's not really good for the IRS now. We're using them against them. So basically, the cookie jar provision allows you to keep that income in the trust after you pass away. If the beneficiary wants to leave it in there rather than distribute the income, they can leave it in there and still get the lower tax bracket that they have. That's a long-winded way of saying that, okay? The distribution protector versus the distribution trustee. So this is where after you pass away, right? And so if we have minor children, typically what people will do when they have minor kids is they say, look, let's say I have $1 million to leave Nava, right? And so, hey, she's 5 years old right now. We're not leaving it directly to her, and actually the laws won't allow me to leave my monies to minor, but I can leave money to her in a trust that lays out how I want to use it for her, and I can say, hey, under the age of 25, we're going to have this person manage that money on Nava's behalf, right? From 25 to, let's say, 30, Nava could be a co-trustee. And so, they would have to sign off on, if Nava wanted to buy the Porsche, the co-trustee would have to sign off. So there's a training period with regard to that. And then after 30, she can fire that person, giving her ultimate control. So it gives her some training before she gets to that, right? I'm talking about once you get to that point where that you're fine with how the beneficiaries are handling their financial assets, that now it's really a matter of, do we want asset protection for them? Okay. So if we have $1 million, I would say, hey, let's protect that. And so let's say, if, Nava got married and divorced, I don't want that money to go to any ex-spouses or if she got sued. And so that's what those protective trusts are all about. I call them the school bus trust, is that she can access it, but other people can't. But that will only work. There's a higher degree of asset protection is if she has somebody working with her that can sign off when money comes out of the trust. And typically we would give the clients the option, hey, they can add a distribution trustee. Nava could do that, and she could remove and fire them anytime they want. But a distribution trustee would be one where anytime money's coming out of that trust, get that second person's signature. Often we would serve there, so that if she did get sued or divorced, the judge would look at it and say, every time you took it out, you had to get a second signature. Okay, you got to get a second signature now, and good luck getting that law firm to sign off on non-permitted distributions to creditors and the like. And that was the idea behind it. No management of investments, right? It's really just an asset protection deal that is available. Well, now the problem with that is that the distribution trustees would have to be listed on the financial accounts. And I don't want to do that. I don't want to be on the financial accounts. And we found workarounds. So now we've got the terminology called distribution protector. It does the same thing as a distribution trustee does, but it mitigates. You're not required to list that next person, that co-trustee, on all those financial accounts. So again, these are process changes that are there to provide, these are for your beneficiaries, okay? And that's what it's all about. And so basically, before, the beneficiary had to list a co-trustee on accounts. Now they don't. You can add a distribution protector to protect the inheritance without being on the account. That's the bottom line. And that's what we're putting in there, unless you said, no, I want this person there because there's other issues going on with our beneficiary that they are not able to manage it on their own. Okay. But if you're like, no, they're fine, they're good, this is just an easier way for them to protect their inheritance, less administration on that side. That's the same thing that I've just been explaining to you before. The digital assets. So digital asset side of things addresses types of fiduciaries. And this is, here's what issues that we're seeing in this area. And this is there a comprehensive inventory of my online accounts, right? That asset review report has your financial accounts, your real estate, any business interests, bank accounts. It doesn't list your Amazon account, your Apple account, all of the other online accounts that you may have, anything with regard to the airlines and points, all of that stuff, right? So the goal is, the point of it is, do you want your Amazon account to be shut down, or do you have, is that kind of a family plan where, no, I've got all my things listed on there, and all of my, and that's going to be a huge undertaking getting it all set up where I have it all. And so we want to make sure, do we want to transfer those, or, my photos, am I losing those? And if you don't have things in place and you're at the mercy at the company's end user licensing agreements, it's really difficult for your family members to get to those accounts if you wanted them to have that access. And then do you use a password service? So these are things that if you do use a password service for online accounts, make sure that the key people that you trust are aware of that and have an idea of where to be able to utilize that if necessary. But in the trust, there's going to be Article 17 language. That's where we have Article 17 is where we deal with trustees and their powers. We're putting digital executor provisions in with regard to that. And I'll explain this because I want to make sure that you understand the digital executive services that we're working with. We've hired we've done a strategic alliance with Directive Communication Systems, DCS. I've been talking about this for about 2 years. We've finally implemented this past year. And so you have all of our clients have access to this service. And you want to look for the email from DCS service with the subject line, "Welcome to DCS. Robert Feisee has enrolled you." All right, that's the email. And then also you can go to InsightLaw.net and to the DCS introductory webinar. I'll show you how to get to that as well. But basically, there's a handout that I provided to you all, and my goal is to get more people using this service, okay? And the idea is they don't have your access to your passwords. We just want to make sure, right, that we have an accurate inventory of your online assets. So there's a digital asset intake questionnaire, right? So please list your personal accounts. If you have these types of accounts, these are digital assets, email accounts, right? Can people have access to your email accounts or not? Do you want them to have that information that might be important for them? Utilities, shopping, right? Incentives and awards, investment accounts, banking. So those are the things that we're trying to kind of capture. And the point of it is with DCS, there will be a way that you can basically, and let me show you because that's just that important. I'll bring it up. So this is our website, and there's info for clients and helpers and beneficiaries tab. And then right there, there's going to be a DCS, basically access DCS digital assets. Okay. And so you're just going to watch that video. If you don't, and that's a very self-explanatory video. And if you do have further questions, DCS provides a lot of information and support for you. They've got a website. And then if you need more, you can call us with regard to it. But the point of it is that you'll be able to then register, have a process that they have just a pop-up that when you go to account to go to certain websites, you'll say, yes, I want to enroll it. And you just click the button. And then they'll ask you, well, do you want it to be deleted when you die or transferred? That's what we're trying to do. Okay. This is our process of adjustment to say, what about all of your digital assets? That's part of your profile as well. And we need to have closure on that, right, when you pass. So that's what DCS is about. That's what we're doing there. And so if you haven't looked at that and haven't enrolled, I encourage you to do that. Everyone from Insight Law has that ability. We've done that. We've incurred that. We've made that investment. We think it's that important. And so we want to, and there's been informational sessions, but just listen to that introductory webinar. That'll get you started on that and review that handout that's been part of the package. The last update that we made is trustee notice requirements. So the goal of this is that with regard to trust, there's three key parties to a trust, and our clients, while you're alive, our clients are all three. Is you're the trust maker, you created it, you're the trustee, you're the one managing it, and you're the beneficiary. And what this is saying is, hey, when you're the trustee and you're the beneficiary, if you're in a married couple and you're the beneficiary of this, and there's no other outside kind of family issues, then you typically in a trust, if the beneficiary wants to have notice of accountings and how things are being operated, they would have the right to do that. But if we're in a situation where we have spouse and then kids, if we have a married couple situation, we just want to eliminate that typically. Look, if you're the one who is serving and it's you or the spouse, there's no, the kids can't require you to do accountings unless there's some specific reason why you'd have to do that, or the further beneficiaries. But after you pass, then whoever the beneficiaries are would be, entitled to those. But usually the beneficiaries are typically them at that time, the trustees at that time, or there's someone who you trust to manage it on their behalf, but hey, they have the right to see how the money's being managed and accounted for. So that's all it is. It's just reducing that requirement when it's the clients that we're dealing with as far as the notice requirements. Federal estate taxes, right? This is dealing with your estate. And so right now the federal coupon is at $11.7 million. It's as high as it's ever been. You can die with up to $11.7 million worth of assets and not pay one dime of tax. Okay. If you go over that, the rate is 40%. And if you're a married couple, we can double that coupon. Okay. This law was passed through what's called a reconciliation. If you remember what I talked about reconciliation, the previous administration did not have the votes to get this permanent. So that is sunsetting. Okay. It sunsets January 1 of 2026. And it goes down to 5 million at that time, unless they decide to do something else. There's talk that they may reduce it down to 3.5 million. But again, this is all talk. We know what the law is, it will be 5. And so some clients who may be impacted, right, are the ones who are over 5 million, right? They're not over 11.7 million, so taxes aren't an issue now. But they're at 5 million or close to 5 million, and so, or over that or between that. So that's where people are saying, hey, can I do something now before those coupons drop or those exemptions drop? And that's some of our clients that are in that level are able to do planning now for that. And portability option made permanent, that is more of a technical term. It just allows you to port your coupon over to the surviving spouse without having to use what we call the coupon trust. Not getting into the weeds of this now. It's just an option that we build into the plan. Just know that we take advantage of it for you. All right. So that's the legal update. Sorry, there was a lot of stuff out there. Okay. Wanted to make sure you guys had the issues covered. So our website, I went over that with you briefly. Just want to make sure you all are comfortable with the website. It is insightlaw.net is the site. And typically, you'll go here for the personal access, but there are resources, right? So we have resource partners, recommended reading lists. These are for, if you're dealing with the grieving process and the like. Resource partners are more, hey, I'm looking for, I need a nursing home or home care or assisted living facilities or helpful websites. I really like David Solis' website. He is one of the national kind of forefront speakers, I would say, on more of planning for seniors. And I'm sorry, one of the things I might do is kind of switch the fonts here, but David Solis his website's pretty cool. And you can see the kind of things that he's trying to address. What can I help you with? Is it a caregiver support, aging alone, declining health and family? So again, these are things that, these are people that have dealt with these issues. We know enough about them, but there's only so much you can be really, focused and good on. And so we want to align ourselves with the right people. But when you go into that tab, right, the tab info for clients and helpers, that's where we have the access to digital assets. We want to have, you want to have access to your portal. My goal is you really need to, I think, start utilizing the portal. If you're not utilizing it from our side, it's a tremendous way for us to communicate with our clients. And it really saved us last year when we couldn't do things, in person and the like. And I don't know how you all are seeing on your end, but on our end, the Postal Service just ain't what it used to be. Okay. And so I think this is probably even safer than that as far as I'm concerned with it. But the portal, looks like this is a kind of a sample one. And that's a way we're eventually going to get everyone's estate planning documents on the portal. It's a way for, with regard to the annual client meeting, all of the documents and the things that we used to print out, right? Kill trees and all that administration. Now we can just, here, it's uploaded. If you want to print it out, great. It's there for you. You just want to look at it on your iPad. Your renewal package will go there. Client update program documents. So estate planning documents, we're working on getting that. We're still, there's only we have a small team and we're growing, but we need to add in, and then funding issues there. So I really like it. It's a great tool for us that we've had. And so if you're not using the portal, please do. If you haven't signed up, please do. And then the required training for a 911 info. This is when you deal with the this is the program that I do live the Saturday before Thanksgiving every year. And this is basically, something happens to you, what does a spouse need to know? Made the 3 or 4 top things, checklist and the like, what do we need to do at the appropriate time? And then even your beneficiary. So the goal would be once every 5 years, we want you attending, and then your helpers attending once every 5 years. And if you can't make the live one, here's the video delay or video program. So every year I'll do it, and then I'll post it on there. And again, the goal is for the clients and the key players to be comfortable with us, know our process, know who to call at the right time. The fillable client documents, these are nothing client specific. Those are those healthcare checklists. You say, Bobby, you know what? I do want to update my healthcare checklist or my final arrangements. Go there, and then you can update them, and you can pull them off of the web, any of these that you want, and that would be a way for you to get that done. DocuBank, I think it's important enough that you know and be comfortable with it, right? DocuBank is the service that we utilize to store your medical directives, right? And you get a little card. I always tell people, this DocuBank card, I want you to sandwich it between your driver's license and your health insurance card, because if you get into an accident, typically the medical, the hospital or the urgent care will want to know who you are and if you can pay, right? And this says my directives can be accessed this way. You can either call a number and it can be faxed, or the person who gets this, or they can go to the website and just pull them, right? And so they can go, there's a docubank.com listed on here, or go to our website that way. And if they just want to pull down and they don't want to actually go into the account and they just want to use what's on the card here, you just can click on that, and there's ways to just get them printed that way. If you want to go into full access of the account, which I want to show you, then you go into member number login. The member number is on the card. The PIN number is on the card, and then the password is your own password. Typically, it's your zip code when you initially enroll, and then you can change it to whatever you want. But when you log in, what I wanted to show you is, yeah, you can actually have your card printed there if you wanted to, and you can print documents. But the other thing is, you can get a medical snapshot, right? All of your doctors and past history you can put on there. That's very useful for healthcare providers if necessary, okay? And I should have put my vaccines and things on there. You can put your vaccination records on there. And so it's a good way. So your helpers or family members, that can give you that. And then if you're taking medications, or a family member is, and there's different dosages at different times, that can just all be added here, and it's all in one place. So there's more to it than just that if you want to utilize it. These are all available for you. That's DocuBank. The video library, those are just videos on different topics that I've done over time. So that's good. You can make payments, suggestions, refer friends. So those are the main items that I wanted to go over with the website. And then and then here we go, the website, and then, okay. Let me just pull this up. So I just went through all of that on the website. And then I did get a question just recently. Will items like it's the master contact list is what we call it, personal item list, be on the portal so I can update as needed? If they're already there, where are they? Okay, so that's a good point. So we've moved over we're moving over the estate planning documents. But as far as the master contact list and the specific special stuff list, those get updated when during either the annual client meeting or the client update program meeting, where we'll have those documents provided to you. And that's the way we typically have done it. And then you update it when we do those programs. And the special stuff list, where you have the special list, that's definitely updated at the client update program, which is this, where that's part of your estate planning review worksheet that I went through. So on your estate planning review worksheet, there's a place where you have that itemized. And if you want to make changes, you'll make changes right there. And so that is there. Now, as far as having them static on the portal, that is something we will look at as well. And then I saw, yeah, contacts can change between those times. That's absolutely true. And so that is something we'll look at as far as we'll have it on portal. You definitely have that list. And if there's changes, you send them to us, but just having the master contact list there, that is something we can look at and have that available. The special stuff list, I would just say your estate planning review worksheet is going to be on your portal, and that can be updated at any time. So that is already there on the estate planning review work. That's already kind of slated to be there. But the master contact list, I've not done that. Should we all be in the process of updating the worksheet for you, or is this an every other year update? So yeah, so the idea with regard to the estate planning review worksheet is that anytime it's your year to update, and typically it's every other year that we're updating your documents, we're going to send you an email saying, hey, it's your year to update. All right. And then once you reserve that, that's when we send the newest estate planning review worksheet to you. And we make that's the formal update. But if you can't wait through that time period, you do have access to your estate planning review worksheet on your portal. And we'll make sure that's really clear for everybody. To where it's at, I'll make sure we can do an email and send it out. But basically, that would be a way for you to update between those meetings, okay? And if you're updating between those meetings, if it's just a word processing update, changing names, beneficiaries, percentages, that's part of your annual maintenance plan membership fee, and we'll get that handled. If it's something that requires counseling, a call with me, we're going to think about issues, go through things. It's not just a word processing change. That's where we get into a personal counseling review, and that's fine. It's just an additional flat fee of $500 where we go through that issue, make sure we got it covered, and then make the update. Okay. Word processing amendments where you just update the report, send it to us. That gets turned around within 30 days. Counseling issue, we need the attorney involved to talk through some issues ahead of time. That would be a personal counseling review before we went into that update. Good questions. And then I have somebody who likes lacrosse. I am a big lacrosse fan as well. So thank you very much. In my former life, I played lacrosse. I was okay. I could hold my own. And then with regard to, and then one last one, cryptocurrency. So we do have some updates with the DCS service. They have a good handle, or they're kind of in the lead on the cryptocurrencies. And so we're going to be doing a program soon where Lee Poskanzer, the president of the DCS, the Digital Communications Directive Communication Systems, is going to do a presentation. We'll put it up on our website about the cryptocurrencies. Okay. And so I'm playing around with the cryptocurrencies myself. And the goal is with these accounts, if you are familiar with them, so like, for example, a Coinbase account, typically it's going to be just in your individual name. And so as the problem that I see with that is you die, how do I get that to your beneficiary without having to go get court orders and the like? So that's what we're connecting the dots. I'm hoping by the end of this year, we've got a good solution, but as you can see, things change, right? And so you can't predict all these things. And these are process adjustments that are associated with that. Okay, the other items, good questions by everybody. Thank you. The paperless portal request form, if you're on the portal, if you're not on the portal, please reach out to Michelle and let's get you signed up. And it has really helped from an administration standpoint for the law firm. The technology, so we're doing a lot of things through Zoom now. My goal is to next year, hopefully we'll have some closure, some clarity, and that we'll be able to do live meetings. But I don't think we'll ever. Now, I think we got Zoom kind of part of the deal, but we'll have live programs as well, but a hybrid type of deal where I'll do a live program, but people can also Zoom in. And so I think that's good. I just had a client advisory board meeting this week. And for those of you who are not familiar with the client advisory board, those are clients who have volunteered, have been and are on our basically as a way for me, a sounding board for me to communicate with the client base, get an idea of the issues that I'm seeing in a smaller kind of focus group. Okay, and so we want to make sure that you're aware of that. And if you are interested, we want to add people to the client advisory board. The client advisory board that we had there are a lot of what I call veterans, and they said we should have some newer clients in here to get their take on things. But they're great, and so it really helps me because I ask them, what are we doing well? What aren't we doing well? What do we need to improve on? What aren't we doing that we should be doing? How can we make things better for the website? Different process issues. I'm able to talk and get things rather than just try to do things without hearing that feedback. And we want to make sure we got it. But one thing that they said that really kind of touched me is that, one thing when I was talking about marketing, and I was talking about, we get most of our referrals from either financial advisors or CPAs, but we're getting a lot of referrals from our existing clients now, which is really helps support us during really difficult times. You can't imagine how important that was for last year to have that. It really saved us to have our existing clients. That means that we're doing something right. And I said, on the marketing side, should we be doing these, the Google Analytics and stuff? We're looking at these things. We don't do a lot of that. And they came back to say, those things are good. But really, Bobby, the personal connection is really why people refer you. They really like that personal component of it with you, and that you come back to your clients. And they did like the live meetings, the in-person contact. They understood last year, what we're dealing with now. But to me, that really kind of got me thinking. Really, that is what it's all about. Is just the relationship with you. And so I get it. Some people, if we can't, always meet in person, but we have these virtual abilities to do that, or focus meetings. I just really like the fact that they had that component to it. So webinar training sessions. So Zoom is part of the deal now, but there are other things that we look at as well. So those are there. The education calendar, the main one that's coming up is the nuts and bolts one. That's the one that goes through the steps that you need to know on a disability or death. Once every 5 years, we want you to go, and then whoever your helpers are. We'll probably do some kind of targeted program on what's going on with the laws once we have more clarity with regard to it. And so look out for it. We'll send it out either in our newsletter or just an email blast with regard to it. As you hopefully can see, we're not trying to flood your inbox. We do not send, we're not trying to be onerous with it, but we do want to give you relevant information at the appropriate time with regard to it. So don't just disregard the emails that we're sending out to you. Housekeeping items, if you do keep a hard copy family organizer, client organizer, then you're welcome to print those out and put those behind those tabs. What we're trying to do is we're going to go figure, have a virtual kind of family organizer that is out there. We're coming up with kind of solutions with regard to it. And that's one thing. Your EPRW is that executive summary. It is on your portal. It is there if you're in this meeting under the client update program. So that's where the EPRW is. And so that's easy to find. If you want to print that out, that could be under the reports, or you just keep it there. And then the funding action item list, that's important. Help us help you, help Ginny help you, help Holly help you. All of the team really works on the funding. And just if there are questions about it, let us know, and let's take a push and get it done. That is it. Okay, so that's about an hour and a half, right on an hour and a half. Hopefully it wasn't too overwhelming. Any other questions that people have, feel free to type them in. But thank you very much for coming. We'll see you at your signing meeting. So we'll coordinate the signing meetings next if you haven't already been coordinated. And we'll either see you there or at the education program, any of our education programs. We are going to try to have a holiday party this year. Hopefully everything will work out, or at next year's annual client meeting. Thank you very much, everybody. Hope have a great day. Hopefully this was helpful for you. If you can't think of any questions now and have follow-up questions, feel free to do that. But really appreciate everyone during this time, and the client base. And so keep hanging in there. I think I see the light at the end of the tunnel with regard to it. One thing that I got one more point is for our clients, that remind clients, one of our client advisory boards, remind clients to pay online. So that is, it definitely helps us when we come with regard to the annual renewals. If you're able to, we'll be sending out, invoices in December. As part of that process, we have an online feature where you can just pay right there. That saves us a lot of time. And so the issue now is we are providing a feature which is basically you can just set up an ACH and there is no charge for using that. The credit card companies are really kind of hammering us on their fees. And so we're working through on, hey, if there's a free option and if there's a credit card option, there has to be some type of fee associated with it. It's been a long time in coming. I don't like going that way, but just like paying your water bill, we're getting to a client base where this is becoming a significant transaction cost for the firm. And so that's something that could be, is going to be coming out with regard to it. But again, it's all about, it's easier from an administration standpoint, from a technology standpoint, to pay things that way. It's efficient. And so that was one item people wanted me to add in there. Thank you very much. With that being said, I will conclude the meeting. Have a great day, and we'll see you at the signing at your time. All right, everyone. Great to see everybody.
Thanks, Bobby.
You're welcome.
Thanks. Have a good one.
You. Bye-bye. Good to see everybody. I can see everybody on there. It's awesome.
Yeah.
All right, let me see if I can get this ended. Oops, I'm not getting it. I need help with technology.